Your return to my CryptoQ Media channel brings me joy. An ex-SEC lawyer named Mark Fagel has come out to shed light on the ongoing legal dispute between the SEC and Ripple by providing crucial data regarding the SEC versus Ripple lawsuit. The U.S. Court of Appeals for the Second Circuit has sent out a default notice to the XRP community, which is an acknowledgement and notice of attendance. This claim has sparked a lot of discussion. The general public views it as a warning to the SEC on its compliance with the processes. Most likely, you are interested in knowing how this could influence crypto policy in the future. Continue reading if you would want to learn more. Fagel made it clear that the aim of the notice is not the SEC's actions but rather Ripple co-founder and appellee Chris Larsen. The court extended the deadline for Larsen'S legal team to file the notice of presence by 14 days after October 18 due to the dire ramifications highlighted by Fagel. Larsen'S legal team is in danger of losing the opportunity to deliver oral arguments if the required paperwork is not submitted by November 5. Failure to do so might catastrophically harm Larsen'S case. In light of the warning, Chris Larsen'S legal plan is in jeopardy. The new deadline of November 5 might lessen Larsen'S impact on the case if his counsel fail to adequately represent him. This case, particularly one as widely followed as SEC v. Ripple, emphasizes the significance of adhering to procedural standards in high-stakes lawsuits. Rational aims to submit its preliminary argument no later than October 25, 2020, as stated by Stuart Alderoty, Ripple's chief legal officer. The purpose of this filing is to contest Judge Torres' ruling on XRP sales to institutions. After then, the time will come to submit the appeal paperwork. Given that the SEC has 90 days to respond, the court fight may continue until around the middle of 2025. Unpredictable developments continue to arise in the Ripple vs. SEC prosecution. What do you think will be the outcome of this? There is still XRP, even though the SEC has appealed. It is not a security. The SEC did not contest the court's determination that XRP is not a security, even though it just appealed its case against Ripple. When it comes to XRP, the Securities and Exchange Commission is fighting several parts of the court's preliminary ruling that backed Ripple. On October 16, the SEC filed a civil appeal involving Form C, a pre-argument statement C, personal XRP by Ripple, sales on exchanges, CEO Brad Garlinghouse, and co-founder Chris Larsen. October 17 was the date on which Ripple's announced the appeal. Defense. In his appeal, attorney James Frazier asks the court to re-evaluate its decisions regarding these two forms of social networking platform transactions. Chief Legal Officer Stuart Alderoty of Ripple responded to the SEC's appeal by saying the business plans to file its documentation the following week. As Seth pointed out in his response, the appeal does not challenge the court's determination that XRP is not a security. According to the lawsuit, Larsen and Garlinghouse are accused of selling XRP in a way that violates securities laws, as well as of helping and enabling violations of those laws. Some provisions of statutes pertaining to the Securities and Exchange Commission are at the heart of the accusations leveled against them. According to the SEC's brief, it is contesting the court's decision to award Ripple partial summary judgment. The manner in which executives sell XRP on exchanges for purposes other than cash, and the distribution of XRP in return for those reasons, are at the heart of this ruling. Eleanor Turret gave an interview to Fox Business 7 days after the SEC filed its appeal, summarizing the anticipated timeline for the appeals process. The SEC indicated in its appeal that these problems are to be evaluated in nova, which means from the beginning. The SEC has up to 90 days to submit its initial brief following the filing of Ripple's Form C, and the parties will then establish a briefing schedule. In July 2023, it was announced that Judge Alicia Torres of the U.S. District Court for the Southern District of New York sided with Ripple, stating that XRP sold programmatically on digital asset exchanges is not a security. The full briefing procedure is anticipated to last until July 2025, according to Aldo. The court imposed a $125 billion fine and in August barred Ripple from further violations of the Securities Act of 1933. Fear among XRP aficionados and general unease in the area have been heightened by this unexpected development, as attorney Jeremy Hogan was unaware of the deadline for filing paperwork with the SEC until a public update revealed it. What happened recently? Where can I read about it? Following the court's directive, let's determine when the Ripple Visas case was adjudicated. Fox Business journalist Eleanor Tourette released a court document after the Commission's first appeal. The judgment from August 7 was overturned. However, the intended docketing of the appeal did not coincide due to a document that was made public by the U.S. Court of Appeals for the Second Circuit. Submitting the sex appeal notification on October 4 under docket number 2426, a decision has been reached about the deadline. The community's perspectives were markedly different before this record was made, as shown in the docket sheet. We will ensure that you are kept informed of any new information regarding this litigation, which will last until the SEC files its Form C. Scheduling a briefing will follow the submission of documents by both sides. By the middle of 2025, the SEC should have presented its opening brief and legal posture, thanks to the additional 90 days. According to a report by Fox Business journalist Eleanor Tourette, the notice of appeal was not legally docketed until October 4, 2024, even though the SEC submitted it on October 2, 2024. It appears that the SEC failed to appeal the XRP litigation by a critical deadline. A lot of conjecture has been swirling around this discrepancy from both legal specialists and outside watchers of the industry. It was originally believed that the SEC had until October 16 to submit the appeal paperwork. However, a document provided by Tourette on October 4 indicates that the appeal was really filed on October 4, so now there's some debate about whether the deadline should be October 18 or October 16. In order for her to gain a better understanding of the situation, he proposed rescheduling the final for October 18 in compliance with the 14-day limit. She reiterated the deadline's timeliness and pledged a prompt response from XRP, mentioning that she was requesting feedback from key individuals. A prominent community member named Ashley Prosper claims that the Army monitored reactions to Tourette's results and that many people base their predictions on the Second Circuit's purpose. While calculating the Form C and deadline, he did inform us that the District Court had received the notice of appeal. He maintains that the filing date is the only relevant factor. The court's procedures state that the 14-day clock began on the day it was submitted, October 2, rather than on October 4, when it was docketed in the Second Circuit. Since Prospero had made a promise to the local Vincent de Pauls, he was on board with the concept. On top of that, Code discussed his views on the matter. He clarified that the notice of appeal was properly filed on October 2, and he brought up concerns regarding the inconsistent dates. Concerning the October 18 deadline, he expressed his qualms. If you believe Van Code, the references given are not valid, and the date of the first filing with the District Court is the definitive reference. Everyone is wondering what will happen next and what the repercussions will be because the SEC may have missed the deadline. The court can still consider the filing date when deciding whether to accept or reject a late submission, according to an XRP community member who made the observation on social media. This is significant because XRP's value has recently begun to climb again, and many are discussing the deadline for the Securities and Exchange Commission to submit Form C. A privilege it is for you to view my video. Subscribing and liking my channel would mean the world to me. Until next time.